Welcome to the Boston Barrister, Kevin Patrick Seaver, bringing you insights about your family and the world.
Welcome to the Boston Barrister. My name is Kevin Patrick Seaver, and of course I'm from Boston, Massachusetts as a lawyer. With me today is attorney Paola Rossetti. Paola, introduce yourself, please.
Hello, Paola Rossetti here.
This week on the Boston Barrister, we're going to talk about modification in the Probate and Family Court of Massachusetts. What is the purpose of modification?
The purpose of modification is to change a court order or request the court to change a court order.
What are some of the categories that you'd ask the court to change in a modification?
You can ask them to change child support, custody and parenting time, alimony, and other matters.
What is required to bring a modification forward?
The person bringing the modification needs to show a material and substantial change in circumstances since the court order was last issued.
Substantial and material change in facts. So how about an example of that? Because that's kind of like mumbo jumbo legalese stuff. So let's break it down into simple terms that everyone, including me, can understand.
That's right. So one example is for child support. Maybe the parent who is providing child support lost their job, so they have less ability or no ability to pay temporarily.
And is the opposite true, where someone all of a sudden gets an inheritance, hits the lottery, gets a promotion on a job, and you want to increase that? Would that be a substantial and material change of facts where you go into court and ask for modification?
Yes, that could definitely be one of them.
How about another example of a modification?
It could be the child's needs change, such as they have to go to a private school that's in a different location, or they have different medical needs.
What's another example of where modification needs to occur?
Could be a child's mental health issues or condition comes out when they get older and they just have different needs that require a different change or a different circumstance of custody.
What are the steps you have to take when there is a material or a substantial change to do a modification? How do you start that process? What are the steps?
To start, you need to fill out and file a complaint for modification and include with that an affidavit supporting what is this material and substantial change in the facts that have happened. And you're going to want to need to serve the other person after you get a court summons to appear in court on the modification.
Is there anything else that really helps you? Because we all want to be in it to win it.
Yes, in your affidavit, you want to state specifically the facts that you are saying require the modification for.
So on the pains and penalties of perjury, you file an affidavit indicating the substantial change in facts that should lead the court to agree with you that there is indeed a modification that is necessary for all the right reasons, such as the best interest of the child, right?
Yes, exactly.
Okay. So in each and every case, you have to make the other party aware of what action you're taking. How is that done in a probate and family court regarding a modification?
Once you file the complaint for modification, the court will then issue you a summons, the moving party, and then you need to serve that summons to the other party.
So how do you have the summons served?
You first want to try sheriff or constable or process server in hand to the other party. If that doesn't work, you can file a motion for alternate service with the court where you show that you tried to serve the other party. Maybe they're trying to avoid it or they haven't been home, and then you can ask to do it service by mail or publication.
Well, they're trying to dodge you, right? I mean, They know that there's perhaps been some talk or discussion or even emails. You may even have sent a letter, which I always like to do, so you're wearing the white hats when you go back into the court and you're in front of the judge. You want to show that proof by talk about the letter you sent, and if the judge wants to see it, how can I approach? And you show that you're trying to do the right thing. That's the most important thing. Would you agree?
Yeah, I would agree.
What are some of the categories of modification when it comes to child support, which is a huge issue all the time in the probate and family court?
Some categories are the paying parent loses their job or gets a large bonus or increase, so the opposite, they are making a lot more money, or the receiving parent loses a job or loses government benefits, something that makes them less able to provide for their children.
How about change in parenting time? Does that become modified or is modifiable?
That can be modifiable depending on the circumstances. So a change from primary custody to 50-50, as one example, would impact the amount of child support per the Massachusetts child support guidelines, and you'd want to file modification to tell the court about this change.
But you got to be careful here. It also may not have changed it. Is that correct?
That's correct. It's not automatic.
The bottom line is go in with things that are meritorious, that need to be modified. Don't be running to court every time. It's like the kid that cries wolf, that when there actually is a wolf, no one pays attention because you've cried so many times. Well, it's no different. They don't want to hear all the fluff. Nobody does. When does the time and the clock start ticking when you're looking to modify child support?
When you're looking to modify child support, it's in part based on the date you file the modification. So if you find out a big change happened, but you wait months or even a year to file, don't expect to get money back or less money decreased before the date that you filed.
So what you're saying is not retroactive.
Exactly.
You can't sit on it.
Right.
If you knew that the spouse got a bonus or inheritance or a job promotion, you can't go in sometime later and say, wait a minute, Judge, he got this promotion 6 months ago. And the judge is going to say to you, well, where have you been? You can't sit on it. So the date and the time that you file the modification, that's when the clock starts ticking. So as soon as you learn of this, don't run to the court and file this. Can the parties modify an existing court order without going to court?
Yes, they can. They would come to an agreement, and you'd want to put that agreement into writing and then submit that to the court. And the court would have to approve it, and then it's enforceable.
Little caveat, if you got an agreement and stipulated the parties and you get it signed by a notary and take all the possible, what I would call fraud, you may ask for it to be done administratively. You might get that done by some judges, but they may want to hear from you too. But it'd be an uncontested hearing, which should be short and swift. In other words, be creative. Again, court time is precious, judicious time. Courts are busy, judges are busy, the clerks are busy, the staff are busy. Remember that. Do not waste people's time. Get in, get out, get your business done. And if you can do it administratively, by all means do it. And if you don't have to, then if you settle on something, it's an uncontested hearing. You go in, the judge will do a little colloquy, and out the door you go. Short and sweet. What happens regarding modification when the child turns 18?
Well, a parent can still bring a modification for child support to ask the other parent to help pay the child's college tuition if the child is going full-time to school.
And can you do the opposite where the child's not going to school, reaches the age of 18, is not living in the parent's home? Can you move for modification, dismiss the child support?
Yes, you can.
What are the three circumstances where over the age of 18, you continue to pay child support or you can have it dismissed and modified?
The one is if they're 18 to 21, living full-time at home and dependent on the parent, the child support can keep going. But if they move out of the parent's house and are not living with either parent but on their own at 18 or older, then you can move to have it dismissed.
And what's the other two circumstances where the child support can be dismissed?
The second one is if they turn 21, they were living at home and they still are, but they're not enrolled in a full-time college or job training program. You can move to have it dismissed.
Then the third type?
Third is when they turn 23, regardless of what they're doing, full-time college, full-time living at home, there's no more child support.
There's three different situations. One at 18, if they're living at home up until the age of 21. Then at age 21, even if they're still living at home, but they're not going to either college or job training, then you can dismiss at age 21. Child support, modify it. Then the third type, regardless if they're living in homes, they're going to college or job training at age 23, that's when child support meets its final end.
Yes.
What does one do to try and modify child custody?
The rule is still material and substantial change in circumstances, but some examples might be one parent relocates to another state or far away on the other side of the state, so that the parenting time schedule has to change a lot.
What other circumstances would lead to material substantial change in facts regarding custody?
It could be that one parent remarries and that the spouse of that parent is taking on a lot more responsibility for the child, or even taking away a lot of the time of that parent so that the child gets less time with that parent. The other parent may want to file for a modification for more parenting time in some cases.
What other circumstances would you want to go in due to change in circumstance of material facts regarding modification of custody?
If the other parent develops a substance abuse issue or has a longer term medical illness or any other illness or type of circumstance where they cannot care for the child, and it doesn't have to be permanent, but it can be on a temporary basis too.
Such as mental health as well?
Yes, including mental health.
Change in job circumstances where one spouse has to work a lot more hours, therefore has to change the custody, either up or down.
That's right.
One has less work hours and they have more time. But those type of situations, aren't those better worked out outside of court?
Yes.
Reaching an accord, an agreement that, hey, my job has changed. Can you take on more hours or less hours?
Yes, that's a great point.
Can you modify alimony?
Yes, you can.
What is the process for modifying alimony? And give me some examples.
It's the same process in terms of showing a material and substantial change in facts or circumstances since the alimony was ordered. And you'd want to file a complaint for modification of alimony, get that summons from the court, and serve the other person properly.
So you're giving the other party notice, which is very important. There must be fair notice regarding opportunities to be heard. So how do you serve that summons, Paul?
You serve it by sheriff, constable, or process server first.
And if that doesn't work?
If that doesn't work, you can file a motion for alternate service with the court.
And what would alternative service be?
It could be mail, or it could be, if you cannot find the person at all, by publication.
So, Paola, give me some examples of when you'd want to have a substantial change in material facts and modify the circumstances of the alimony.
The big one is if the other spouse remarries, usually the receiving spouse of alimony. Another one is if the paying spouse reaches retirement age.
How about death?
Death is certainly one as well.
Unfortunately.
Yes.
Okay.
Mm-hmm.
What else?
If the spouse who's paying loses their job, or the opposite, if the spouse who's paying or the receiving spouse gets a huge increase in salary or a huge bonus.
How about inheritance?
That too, if they get an inheritance, that may go to their ability to pay alimony and how much.
So the reason for alimony is that one person may have a lower economic ability to earn a situation, and so the other one who has a better position pays a little bit so that person can have a life too, so that they're not suffering. So divorce is hard enough. But however, on the other hand, if one person is paying, let's say person A is paying, and all of a sudden they're paying to person B, and person B gets a windfall of whatever it may be, a new job, big bonuses, inheritance, hits the lottery, wherever it is, we want to keep things even, Steven, or level, or fair.
That's right.
That's what alimony is about. And it's not fair if the one who's receiving alimony goes off and gets remarried, all bets are off. Alimony should be modified, and there's other circumstances. Remember, keep this in mind, that when all is said and all is done, when you're looking to modify alimony, in most circumstances, the judge is going to use discretion and try to level the playing field, if possible, to be fair. That's why we go to court for justice. The judges want to be fair. Often in cases, if somebody, let's say, is working overtime, and you go in and say, well, judge, they're working overtime, so I should get paid more child support. The next thing that ex-spouse is going to do, they're going to stop working overtime. And then the argument is moot. So you walk this fine line here. And I think that things that I believe you should do is talk to the other spouse. Say, I know you're working overtime, you're making more money. Can you pay the swim lessons or the ballet lessons or the cheerleading or the softball or the baseball or the football or the hockey or lacrosse, whatever it is? Don't always go running back into court. That's the last thing you should do. There's precious judicial time. The judges are busy, the courts are busy, the clerks are busy, the staff is busy. Everybody's busy. So if you can work it out positively, do such.